Please the court, ladies and gentlemen of the jury. It is really a distinct honor for me to sum up on behalf of my client, the daycare, in this negligence action. Ladies and gentlemen, we all know that unfortunately in America, in a very litigious society, where there's injury, we want to find someone to pay. But that is not the law, ladies and gentlemen. Where there's injury, we have to find out whether there's a party that is responsible. And I'm talking about legally responsible. So the law of negligence, by the way, have 4 components. One component is there has to be a duty of care, an obligation of a duty to care to the plaintiff, as well as whether the breach of the duty of care resulted in an injury. And by the way, that third element raises the issue of causation. That the breach caused some kind of injury or led to some kind of injury. And then the fourth is obviously damages. Now in this case, the issue of damage of $115,000 has been stipulated. So there's going to be no dispute over the $115,000. Of course, there's an additional claim for a $50,000 payment suffered. Now, in order to really assess this case in terms of where responsibility or liability lies for JR's injuries, we have to look at what really happened here. And I submit to you that by and large, the evidence that's presented is not in dispute. Clearly, JR, on his 4th day in the daycare, decided to scamper up on this changing table and then fell and suffered serious injuries. Multiple fractures on his left arm, including potential disability due to injuries to his tendon. That's not dispute, ladies and gentlemen. And we as parents, caregivers, as well as human beings, we empathize, we feel sorry of this accident. We also have a sense of compassion, not only for JR, but also for his dear mother. She's a single mother, she's a widow, she's raising 2 kids. She's obviously a woman who is highly responsible. However, the issue to determine what led to this fall, that is something that you, ladies and gentlemen, has to look at the evidence, review the evidence, and come to a conclusion based on the credible evidence. What was the causation that led to Junior, JR, to be in this daycare on his 4th day, to scamper up to the top of that changing table and suffer a grievous fall? Now, another area that is undisputed in this case, based on the testimony of 6 witnesses, as well as 2 pieces of documentary exhibits. I will call it Exhibit A and Exhibit B. Exhibit B is the test for hyperactive and impulsive disorder prepared by a child development expert, Dr. Baldwin, in which he tested JR for HID, or hyperactive impulsive disorder. That was tested before JR enrolled in this daycare. And ladies and gentlemen, in this report that is Exhibit B in evidence, prepared by Dr. Baldwin, there are 12 different criteria or indicators that he relied on to come to the conclusion that JR suffered from HID. And one of the areas that's very interesting, that is item 11, says, often runs or climbs when he should not, among other hyperactive and impulsive behavior. And ladies and gentlemen, that is undisputed. And another piece of evidence that is Defendant's Exhibit A, that is the enrollment form or application that was completed by J.R. Munner. And on this form, by the way, it's a 2-page form, and it's signed by Sean R. Wright. And on this form, by the way, if you look at the first page, right on the bottom, there's a question. Does your child have any behavioral problem, e.g. hyperactivity? If so, please list it. The mother wrote down no. And look at the second page before she signed it. There's a caveat. It says, we must have accurate information about your child. Please review your answers and verify their accuracy. Sign below if you have answered everything to the best of your ability. Thank you. Signed by the mother of J.R. So, ladies and gentlemen, this non-disclosure is fatal to the plaintiff's claim. And on top of that, prior to the submission of this form, mother was interviewed by the director of the daycare. And during that interview, the director questioned her. Is there any behavioral problem with JR? And what did mother say? No. Now, whatever reason or whatever rationale mother relies on to give that answer doesn't help her in this claim of negligence. Now, in fact, ladies and gentlemen, mother engaged in intentional and active concealment of JR's HID syndromes or disorder. Mother is fully aware that JR was asked to leave the prior daycare after 4 months because he had serious behavioral problems. He was causing disruption. They transferred one classroom to another classroom. He jumps up and down. He runs around. He was uncontrollable. And in fact, the teachers and at the earlier daycare cannot handle him. So mother was fully aware. The neighbor, right? JR was wrecking the poor lady's garden. Not just trampling on it, but pulling the roots and whatnot. All right, so mother is aware. And mother's babysitter was also aware. It also made mother aware that JR is uncontrollable. JR has certain problems that has to be dealt with. I have no doubt that JR, as a 3-year-old toddler, is probably extremely cute, adorable, huggable. We love it. He's very, very active. But he has a problem. A problem that has to be dealt with, either by therapy, medical treatment, or whatever the case. And I'll tell you one thing, ladies and gentlemen. During the course of this trial, you noted the mother justified the non-disclosure is because she believed this notion that she doesn't want her son to be labeled, to be basically identified as a special need child. And on top of that, by the way, her failure to disclose may be noble, may be justifiable in her mind. It was misguided. She not only put JR at risk, she also basically is the causation of this accident. In fact, the law does not require the daycare to ensure their care from any kind of accident. Only reasonable care in conformance with the state standard. And the law does not impose on a daycare, particularly this daycare, to keep an eye on JR. Because if they were made aware of JR's disruptive behavior, uncontrollable behavior, they may very well have given him special care, more precaution, more monitoring, Or they may very well have rejected him in the enrollment process, like the other daycare. And then also, by the way, the evidence is clear that it's on the 4th day of his enrollment this accident happened. So the daycare did not even have the opportunity to observe him over a longer period of time. They may very well have called mother and saying, hey, you know what? We don't have the resources, we don't have the ability, and then also whatever you're paying doesn't justify us to give your son that kind of unique, special care. Because he's a danger. And guess what happened? He stamped her up. You know, during a brief period, suddenly he jumped on top of this changing table and fell. I don't blame it on any cookies that are on top of that changing table. I think that's all speculative, that he was going up there because of the cookies. Okay? And I also want you to know that we all know, as a fact, everything that the daycare did in terms of trying to care for him, immediately responded to everything in full compliance. And another thing that is worth noting, this daycare has been open for 10 years. They never had any problem. They've never been sued. There's never been any claim of breaching their duty of care. And on top of that, changing table in the back of the room in a daycare for toddlers is normal. Come on. What are we talking about? Who the hell expect JR to do this, maneuver? I mean, that's unusual. For such a short period of time, he stamped her up there, and then what is he? He's a gymnast, or you want to see if he can make a dive? So, ladies and gentlemen, we've got to be reasonable. I can give you a number of examples. If mom has not disclosed that JR is allergic to peanut butter, we all know daycare centers constantly treat kids to peanut butter and jelly sandwich. And then if JR suffered a serious allergic reaction, would anybody claim, or would anybody take the position that the daycare is liable or responsible? If mother has said, no, he's not allergic to any food. Likewise, if any one of you decided to run down the stairs because the elevator is malfunctioning or you can't wait for the elevator, and along the way you took a tumble, would you be able to sue New York Law School for injuries? Of course, unless there's a banana peel that the school is aware of. Come on, you suck it up. Come on, why were you running down? Whether you break your neck or you break your leg, it doesn't matter. That's common sense, ladies and gentlemen. We've got to approach this case in terms of mother's active concealment, knowingly, willingly, for whatever reason, that negate any kind of claim of negligence. So, ladies and gentlemen, if you reach the decision that there is no negligence, you stop. There's no need for you to talk about pain and suffering and any other issues. Because you, ladies and gentlemen, will render a fair and just verdict pursuant to your oath as jurors. You've got to abide by the law as well as your oath that jurors render cases based on the law as well as based on the credible facts. And in fact, that before the case is given to you for deliberation, the judge will charge you on the law of negligence and the standard, the legal standard that you would use to evaluate this case. And I am confident that you will follow the law and you will not be swayed by sympathy, emotion, or whatever factors that are not relevant under the law, and render a verdict in favor of my client, the daycare center. Thank you very much.